I want to get to Mike Farris. He is with the Alliance Defending Freedom and has given us some time today, I'm sure from probably Washington, D.C. Michael, how are you, sir?
I am doing fine. Have a great day. And yes, I am calling you from Washington.
Yeah, well, I appreciate your time. I know you're the CEO of the Alliance Defending Freedom, and your organization helped take up this battle on behalf of Trinity Lutheran. Let me get your reaction to the Supreme Court decision today.
We were very, very excited about the 7-2 favorable vote ruling that religious people and religious institutions cannot be discriminated against simply because of their religious character. It's a great day for equality for religious people, and we're thrilled.
So what's is there a broader scope here? There was a lot of talk about the Establishment Clause and all of this, and I never felt that the state of Missouri would have been trying to establish a religion by giving some rubberized coating to the Lutheran playground, but some people worry about things like that.
The lower courts worried about that, and the state of Missouri, at least the prior administration of the state of Missouri, worried about that as well. And the Supreme Court said that the state's more stringent Establishment Clause, when applied in this context, violates the federal free exercise clause, because the principle here is one of equality for religious people. If we were talking about, the government doesn't have to create programs like this. Whether or not they have a playground safety program, that's entirely within the judgment of the state of Missouri. But once they start one and they say all nonprofits can apply, then religious nonprofits can apply as well. And that's a broad general principle the course endorsed today in pretty much any context, maybe some minor variations here, but pretty much the broad general rule. Religious people or institutions want to participate on an equal plane with everybody else in society. It's perfectly constitutional, and to keep them out is unconstitutional.
So I'm trying to speculate here on whether or not how far this ruling might be able to be carried. If a non-for-profit charter school is able to get state funding, could a non-for-profit Trinity Lutheran get state funding for educational purposes?
Well, it would depend somewhat on the nature of the school, though. There is a distinction in many state laws between a charter school, which is just it's a public school operated in a different context.
Okay.
But if it's a true private school, so if Missouri or any state had a program, we finance all private schools in Missouri, but we limit and say religious schools can't participate, or they say one denomination of a religious school can't participate. Either of those scenarios would be problematic, especially the one where they say only a particular denomination can't participate. So this is a broad statement. If you read the dissent here, they viewed it as a very broad declaration. The exact parameters remain to be seen. The one area where the court made it clear that you can't go, it's too far to go, would be to have state programs being used to pay for people to be trained to become a pastor, ministerial training.
Sure.
That was an exception the court recognized. A prior case had dealt with that, and they made it clear that case wasn't being disturbed here.
Well, Mike Farris, congratulations, a tremendous victory, and thank you for defending Trinity Lutheran and taking this all the way to the Supreme Court.
Well, our team did a great job, and we're looking forward to continuing. We have another case the court just granted review on this morning, with another important religious freedom case next fall, so we look forward to talking to you about that in due course.
I hope so. Mike Farris, thanks so much for your time.
Thank you.
You bet. CEO of Alliance Defending Freedom, calling us from the nation's capital.